Hi, this is attorney Sherry Stinson, your Palm Harbor estate planning attorney. And today I wanted to talk to you about how to avoid probate. This is absolutely one of the most common questions that I get in my office. So this video will talk a little bit about that. The first way you can avoid probate is by putting beneficiary designations on your accounts. So things like your checking account, your savings account, IRAs, annuities, life insurance policies. These are all independent contracts with whoever has this particular asset. And if you've put those beneficiary designations on there and you've done it properly, your beneficiary should be able to provide a copy of your death certificate, and the institution will pay out directly to whoever you have named. And so a lot of times I'll see somebody who maybe they've got a small account, they never put a beneficiary designation on it. And this can really create big problems because even in a summary administration with a very small estate, oftentimes those filing fees and the attorney's fees that you're going to pay to get that particular asset will basically eat up the value of the asset. So if you have any of these accounts, make sure that you check and see if you have the beneficiary designations on there. Now, if it's a particularly old account, or even if it's not an old account, but maybe you just haven't checked it within the past year or so, make sure that the person that you've named on there is absolutely the person that you want to receive that asset if you die. Now, the second way to avoid probate is through creating a document called a revocable living trust. This is a major part of many estate plans that we see, and it's a set of instructions about what is supposed to happen to your assets while you are alive, if you're alive and incapacitated, and also when you die. Now, the biggest problem that I see with revocable living trust is that people do not create a link between the asset that they own and the document that they've created. So you may go into an attorney's office, sign a trust document, and say, great, I'm all set. But I oftentimes see that attorneys do not provide funding instructions on how to create that link between the assets. And if you've not created the link, then you're probably going to end up going through the probate process, which can be expensive and time consuming. So if you've done a revocable living trust in the past, you want to make sure absolutely that your assets are aligned with the document itself. And if you're thinking about creating the document and you actually do it, make sure that the attorney you talk with tells you how to put those assets inside the trust. Otherwise, your heirs will have a big problem on their hands. As always, we love answering questions. If you have questions, please give my office a call at 727-351-7057 or visit our website below. There's a link in the video at www.stinsonlegal.com. We're happy to answer any questions that you may have. Thanks for watching and have a good day.